Well, Mr. Beckles, welcome to the Marcia Week Show once again, sir.
Yes, good evening, Marcia. Good evening to everyone, and hopefully you're hearing me loud and clear.
Yes, loud and clear. And all of those who were messaging me, they want to see Corey come back. Give him more time. He's back. I can't give him any more time tonight. He has 30 minutes. All right.
Uh,
And he will use the 30 minutes and he'll come back and you'll come back next week, right?
yeah. Well, as I said, as long as time permits, as long as the schedule permits, I should be here next week.
Next week. Yes. Thank you. It's an honor to have you. Go ahead, sir.
Yes, right. So the topic is probate issues in the ownership of property. I know if persons can remember last week, I spoke about one of the major issues with last will and testament, with the last will and testament, is where persons may believe that they own the property. And within or inside of their will, they transfer, they give the property that they believe that they own, they give it to one of their beneficiaries. And it is very important when we're dealing with probate matters, not just with wills, but when a person dies without a will. So we have a person who dies having a will. We call them dying testate. They die testate, Testate. But when a person dies without a will, they die intestate. And very, very important that we understand those two terms. So you die intestate means that
Okay, can you hear Attorney Beckles or it's mine? Can somebody let me know out there? Can you hear Attorney Beckles?
all right, I think I'm back.
You're back. Okay.
Yeah,
It's
yes, I'm
okay.
back. What was the last thing you heard?
Tested and not tested. Not
Right, yes.
yeah.
Right, yeah. Two very important terms. And simply, testate is when you die with a will, die having a last will and testament. Intestate is when you die without a will. When you have your will contain the names of your beneficiaries. But when you die intestate now, the Succession Act determines who your beneficiaries are. In
Okay.
fact, even if you die with a will, the Succession Act will still come into play. But with the will, you have more flexibility in determining who you want to give your property to. Now, coming now to the issue, that specific issue of property ownership. Now, you can either own property, we're talking about owning property jointly. You can own property as either joint tenants or tenants in common. And this is important when we're dealing with probate issues. If you own property as joint tenants, and we will deal with one of the most usual types of property, which is real estate. So a person may own land or may own house and land with another individual, co-ownership, but they own this property, this real estate, as joint tenants. Joint tenancy simply means that both persons have 100% share in the property. The interest, each person's interest is not separated. If you have two joint tenants, you can have three jointly owned tenants, you can have four individuals can jointly own property. But as long as you are joint tenants, and you can look for this word, for those of you who have your title deeds, who already have your papers for your property, look within your title deeds. If you own property along with someone else, look in your title deeds, look in your conveyance for the words joint tenants. And once you see those words, that will determine the kind of joint ownership that you have along with that individual. And then, yes, I see a comment here, tenants in common. So we have the joint tenants in common. If you do not own, if we're talking about co-ownership, if you do not own, if you're two or more persons owning property, if you are not joint tenants, it means you are tenants in common. And tenants in common each have a share in or a portion of the property. They have their individual share or portion in that specific property. So we have the two terms, joint tenants, tenants in common. Now, when it comes now to succession, when it comes to probate issues, if you die as a co-owner and you are owning, or you and your that individual, your partner, your co-owner, owned it as joint tenants, there is something called the right of survivorship. So in a joint tenancy, whoever is the survivor takes the entire interest of the ownership of that property. So for example, two individuals own land. One individual dies. The survivor takes the entire portion.
Yes.
So the person that died, they may have children, they may have a spouse. The spouse or the children will not be able to inherit under a joint tenancy, because as long as one co-owner dies, as the entire estate, the entire property or ownership of the property goes into the hands of the survivor. And that is important. With tenants in common, you can determine what you want to do with your own share of that property. So you can give your share as a tenant in common. You can give your share in your will. You can give your 50% share or your 30% share to your beneficiary within your will as a tenant in common. Joint tenancy is a little bit different. Because joint tenancy now determines what you can do with that property after, or what can be done with the property after you die. Because if you're a joint tenant, as I said, the survivor takes the property, takes the entire interest in the property. Now, if you want to give, if you're a joint tenant and you want to give your property or your interest, whatever interest you have in that property, to a beneficiary, you have to sever the joint tenancy.
Okay.
Meaning you have to make sure that that joint tenancy is no longer has any legal authority in the eyes of the law. That's what we refer to as the severing the joint tenancy. And you can sever the joint tenancy by giving a notice. Going to, well, you can prepare, but I always advise individuals to seek legal advice. Go to an attorney at law. The attorney at law will advise you what to do in these circumstances. But there's a document called a notice of severance of a joint tenancy. And this notice should be registered just like any other conveyance, just like any other document dealing with a real estate. Register that
Okay, I think he's stuck. He's stuck again. So we just wait. Guys, in the meantime, if you can hear me, please like and share. Tonight is about education, education, education. All right. All the way, all the way. And so we're waiting. It's Wi-Fi. Yeah. Yeah,
All
you're
right, yeah,
back.
yeah, but
You're back.
internet is, yeah, we're
You're
having some
back,
internet
and you have
issues.
a question. If the tenancy, you know, if it includes investments as well in terms of assets.
Yeah, jointly owned. Anything that is jointly owned. The general principle is that the survivor, whoever is alive, whoever remains, takes the ownership of that property, whether it's real estate, even a bank accounts. So you have a jointly owned bank account. Whoever survives will normally take what is inside of the account. It's called the right of survivorship, and that applies across the board, unless what we call a contrary intention is showed. But when it comes to real estate, your intention, let's say you want to make sure that even if you pass, even if you leave this world, you are still able to give something to your beneficiaries. you need to sever that joint tenancy. And I think
Ah,
before we had some internet issues, I was speaking about the notice of severance. And
mhm.
that notice of severance is what we call a manifest intention. It shows the world
Yes.
that you intend to sever this joint tenancy. And you don't intend your co-owner, even if you die, you don't intend that co-owner to take the entirety of that property. You
Hmm.
want your portion for yourself,
Yes. So your
right?
children or whoever can get it.
Correct, correct. And you can jointly own property in different shares. So normally we are aware of a 50-50
Right.
split, but you can have a 70-30 split. You can
Hmm.
have a 40-60 split. So there are different shares within joint tenancy or within co-ownership. And that is very important because some individuals, um, unless there is some document, and this is important for persons who are living together as couples, they may not be married. But sometimes we have couples who are living together and they jointly acquire property. They go to the bank, go to the credit union, they get a mortgage, and they acquire some portion of property. But no one may, none
He's stuck again. He's stuck again. Okay. We will wait. In the meantime, guys, like and share. What you can also do, you can type your questions and send them to me on WhatsApp,
right.
and I will send them to him as well. There is a question on the screen while you were stuck, but finish your thought and then
Or
yes, yes.
right, right. So those individuals who jointly acquire property, they may not discuss the share, how much each individual will have in that property. But as long as you're in a relationship, romantic relationship, you're acquiring property, it is normally 50-50. Couples will normally agree. It
That's
is
standard. That's standard. It's 50-50.
usual. Usually is a 50-50 split,
Okay.
especially when you are approaching the bank, you are purchasing property, and especially the legal conveyance itself
Mhm.
will have joint tenants, or it may have tenants in common.
Mhm.
And persons usually believe that is a 50-50 because you have joint tenancy in the conveyance, because it is a couple, it's 50-50.
Mhm.
But issues can arise. We're still talking about probate, but
Mhm.
issues can arise when one
Okay, we're stuck again. Let's
right.
continue. Let's continue.
Yeah,
Go right ahead.
yeah. So issues will arise when one person in the relationship puts in more than the other. So we know that when we are approaching the bank, we have a deposit.
Yes.
One person may pay, let's say the deposit is $10,000. One person may contribute 8,000, the other person contribute 2,000.
Right.
So as I said, when everything is going well, everybody is 50-50. But when problems come in the relationship, then you find that persons, they rely on how much they would have put into the property. Once everything is going well, it's 50-50. But
Mhm.
when something happens and let's say you break up, let's say something happens and you need to approach the court to determine how much am I going to get out of this property. Let's say the property has to be sold. How much equity do I have in this property? You find that some individuals will say, well, 50 for me, 50 for you. Another individual will say, no, I put in 80% of the
Yeah.
financial resources. I would like 80% of my equity, and you take 20. When it comes to probate issues, now this is very important. You must know, especially when you are have a joint tenancy, tenants in common, you must know portion of the estate, the portion of the interest that you have in a specific property. Because you can only give in your will, you can only give what you have. That really is the point. If you have a 50% interest, you can give a 50% interest. If you have a 20% interest, you can give a 20% interest. And when it comes down to your beneficiaries, when your will is going through probate, you may have some beneficiaries that say, well, I have a 50% share. Let me go and get my 50%. But then we have the co-owner now, the other person who is involved saying, no, you never, the person that your dad, your family member never had, I hope you're understanding me, never had a 50% share. They actually had a 20% share.
Right. Yes.
So when we are preparing our wills, remember I said your wills must be as specific as possible. If you have a 50% share and you are preparing your will, put inside your will, I give my 50% share in the property, in my property situated at St. Philip, any place in St. Philip. I give it to my beneficiary. Or I give my 20% share in my property in St. James to my beneficiary. Be very specific. We don't want any room for misunderstandings when it comes to property, when it comes to distribution of property. Because you may say in your will, I give my share in the property at St. James that I own jointly, and you name the individual, but you do not state what interests you have.
Right, the interest that you have in there.
The interest that you have is important.
Let's see if we can answer a few questions. I know you still have a lot to say, but somebody says, can you request probate records?
Yes, and probate records. I believe you're referring to applications, probate applications, historical probate applications. Yes, you can. You can request certified copies, and usually you will go to the probate registry. There's a book that you're writing, where you basically state that you want to request. You will need the number. So you need to search your records to find what is the file number of that probate record. Yes. And then you should be able to get certified copies of that record.
Yes. There's another question here. There's a notion. It is not who pay, it's whose name the receipt is made in. How relevant is this here? They're asking, because you're saying,
so this is a very, very important question, very interesting point here. So we do have situations where a person pays, but they give the money to someone they trust to actually pay. Really and truly, the person who pays should receive the beneficial ownership, or they should receive the benefit of the money that they have paid. But sometimes we find that it is the person who may not necessarily have owned the funds. The property ends up going in their name because they're the persons who are liaising, communicating face to face. You may have an individual who's overseas. They send the money to their trusted friend, trusted family member, and that trusted friend and family member is who transfers the money on the ground to the person, let's say the owner who is selling their transfer. And the receipt now is made in their name. But the receipt really is not the important part here. It is whose name the ownership of the property goes into. That really is the important part.
Who owns the property? So you might pay the bill for the owner.
Correct. Who is the legal, whose name is on a legal documentation? So you may have a receipt. You may have a receipt showing that, yes, this receipt is in my name, I'm the owner. But you can, that may really be relevant when it comes to something like a car, chattels, maybe a chattel house. The receipt is important when you're looking at chattels.
That so you can
chattel house. Yeah, you can move from place to place. Or what we
Ah,
call movable property.
right.
The receipt, when we're dealing with chattels, is extremely important because the receipt now may determine ownership,
Ah.
legal ownership. But when it comes to immovable property like real estate, the
Mm-hmm.
receipt is fine, it's all well and good, but it's whose name is on the title deeds.
Right. That
And
matters. Wow.
sometimes we have individuals who may have paid money for the title deeds to be placed in their name, but then the title deeds go into somebody else's name. Because that somebody else is the person who was on the ground, who was communicating with the owner, who was selling the property, they're transferring the property, and now the owner is not aware what is going on. The only person that is aware is the person who is receiving the money on behalf of their friend, on behalf of their family member. So the owner knows he's selling, he or she is selling, and all they're concerned with is getting their money to sell the property.
Yes.
So the owner, so the person who's receiving the money from their trusted friend overseas is going to can possibly tell the owner, listen, this property has to go in my name. And what will happen is that the property goes into the name of the individual who gives the money.
Yeah. Wow. But
But that is not necessarily fatal.
yeah.
So the person overseas who would have paid the money to their trusted friend so that their trusted friend can pay the owner of the property, it is not necessarily a fatal circumstance where they cannot have or cannot get a beneficial ownership in the property, but they have to go to court for the court to declare that they, even though the conveyance is placed in somebody else's name, the person who actually paid it now is the beneficial owner. They now have an equitable interest in the
In the
property.
property.
And I'm
There's
getting into very technical
yeah, but
legal
it's very
issues.
interesting actually. The does 50-50 have to be stated? You know, when you talked about a romantic relationship and you have property and so on and mortgage and yeah, all of that, does it
Yeah.
50-50 have to be stated, or does the court assume, seeing that you're in a relationship, that it's 50-50?
Right. Now, the court don't necessarily assume, but there is a presumption.
Mm-hmm.
There's a presumption that as long as you are joint tenants, there's a presumption that is 50-50.
Okay.
Right? So you can say that, yes, the court assumes, but the legal term really is a presumption.
Mm-hmm.
The court will presume that there's a 50-50 unless there's something that says otherwise. The court will normally presume that it is a 50-50 split. But that
Yeah.
is why it is extremely important. Any document, conveyance, normally in conveyances, we just say joint tenants. In a will, you can give your property to more than one individual. And the words that will normally follow that gift is in equal shares. So I give my property in St. James to my two children in equal shares.
Mm-hmm.
That's important. Or I give my property in St. James to my two children in as tenants in common, giving 60% to one, 40% to the next. Specificity is extremely important when it comes to property, when it comes to probate, when it comes to preparing your wills. Make sure you are as specific as possible. I can't say that enough.
Yes, I got that. I got how long, and I see Dr. Aline is here, people. I think he might be having some troubles. I don't know if Dave can reach out to him, Dave, to see if you can help him. He's probably having internet issues. But somebody has a question here. How long does the process of pursuing letters of administration take? Remember you were saying you a notice? Yeah, go ahead.
Right. So letters of administration, now letters of administration, that is the application you will make when a person dies intestate before the will.
Right.
Now, how long it takes? There is no, I would say, there's no written policy as relates to how long an application or the process of obtaining letters of administration would take. There's some individuals who receive their letters of administration, and when I say letters of administration, it's not more than one document. The actual letters of administration is only one document. One document. It's just a one-page document that we call letters of administration. There's some individuals who receive their letters of administration sometimes in 3 months. The individuals who receive their letters of administration within 6 months. The individuals who had to wait 6 years, 5
Wow.
years before they can obtain letters of administration. It all depends on all of the circumstances surrounding the estate. Whether or not that person had, how many children they had. If you can, sometimes you have to locate beneficiaries. When a person dies intestate, sometimes you have to present more documents that you would normally have to present to the probate registry. And as time goes by, you end up waiting a very long time before you can get those letters of administration.
Wow.
It's
Listen,
very
listen. I know. I see why they want it. Okay, I beg it. Well, I see Dr. Allen is still setting up. I beg you 5 minutes, okay? Because the questions are coming fast and furious. Remember, if I did not get a chance to answer your question, to present your question to, Attorney Corey, Beckles, please WhatsApp me 236-7000. And I will send it off to him. And if it's an issue that he needs to speak to you, I'm sure whatever arrangements can be made. Okay. Does common law relationship, they have 5 years, translate into 50-50?
right. So property is acquired. Let's say property is acquired within a common law relationship. Yes, there is a presumption that it is 50-50. Let's say the relationship broke down. There's a breakdown in the relationship, and one person wants the property sold. They have to go to court. The court would may presume, the court will presume that it is a 50-50. But again, if there is a contrary intention, if there is, remember, there's evidence. Evidence has to be presented. So one party may present evidence saying that they have a 50-50 split. There's a 50-50 split. But the other co-owner may present evidence proving otherwise. They may present evidence, as I said in the previous example, they may present evidence that they were the ones who gave a greater share,
80%, yeah,
into the deposit, into the acquisition of the property. So 50-50 really is a presumption when there is no other evidence to prove otherwise or to show otherwise. That is the presumption.
Yes.
But if there's any breakdown in the relationship,
I see what then
you
they
will
have to put the
find,
evidence. Yes, but the
correct. You will
presumption is,
find that 50-50 changing.
yes, I understand what you,
Changing.
but the presumption is there that it's 50-50. I got
Right,
it.
yes.
So the question on here is it easy to sever a joint tenancy? Does the partner have to agree to the severance, or can they block it?
No, they cannot block. One co-owner cannot prevent the other co-owner from severing the joint tenancy. That is what we call a unilateral decision. And it is a unilateral decision that the courts will enforce. So if you are a joint tenant, you have full authority and full rights to sever that joint tenancy anytime that you so desire.
Okay, so nobody can block it. Question here: when applying for letters of administration, are legal fees based on the value of the estate?
Yes, according to the non-contentious probate rules. Well, non-contentious fee schedule. The legal fees are based on the value of the estate, and there's a specific schedule. Now, I must let persons know that this is the minimum fees that attorneys can charge. So when you read the fee schedule, that legal fee schedule, it would say these are the minimum fees that attorneys can charge. And this is a very important point. When you retain an attorney at law, make sure you are aware how much money in legal fees you have to spend. Don't wait until the end to find out what's the cost. Find out what is the cost of probating the will. Find out what is the cost of obtaining letters of administration before the process begins. This is very important.
Yeah.
So that you can decide whether or not you want to go with that attorney or you want to go look elsewhere. You
Right.
need to know how much legal fees must be paid. And this is important. Just give me one the opportunity to make one further point, Marcia.
Yes.
Because the legal fees are supposed to come out of the estate. So even though the executive
Okay, so he's stuck again, and coming up, Dr. Allen is getting himself ready. I can see him in the green room, so don't go away. Dr. Allen is coming, and Attorney Beckles is stuck. Not literally, but the Wi-Fi is giving a lot of trouble this evening. I hope
yes.
Dr. Allen is going to be fine. Continue, just go right ahead.
Right, yes. So I think I was talking about retaining attorneys. It's very important that you know, you are aware of how much in legal fees will be required to obtain whether letters of administration or to probate the last will and testament of a deceased. You cannot wait, or you should not wait until it is time for the letters of administration to be given to you to ask the attorney how much it's going to cost.
You need to check
Because
before.
the fees must come out of the estate. The estate is supposed to cover the fees.
That is why it is calculated based on the estate, the
Yes, it's
value
calculated on the value of the
of
estate.
the estate, the letters of
So, and
administration.
that is an estate planning issue. So when it comes to estate planning, knowing exactly how much you have to pay in legal fees is extremely important.
Yeah, yeah. Last question here, guys. The last one, the very last one. What about if you marry years after accumulation of property?
Right. So I believe that there was a common law relationship, and the same couple marries after. But the both persons marry each other. I believe that's the question. What the question is saying.
No, I think they're saying that I think they're saying that you have your property, you have
Right.
accumulated your property, and then you marry, you find somebody, a young girl or somebody, and you marry that person. What
Right.
happens then?
Right. So if you marry that person, no, it will have issues depending on the how the relationship goes. If there is a breakdown in that marriage, and the person you marry take you to court, because there has to be a divorce, and there also has to be something called property settlement.
Mm-hmm.
Now, in the property settlement, which is under the Family Law Act, you may have a situation where the court may take into account, well, not may, the court will take into account all of the property, even the property that is brought into the marriage.
Oh,
No,
wow.
no, that's one of the general principles. But that doesn't necessarily mean that the person um, who comes in, who marries another individual, who may have acquired property 10 years before, 20 years before, that doesn't necessarily mean that they will get an interest in the property. But what it means, according to our laws, is that the court will still take into account all of the property. So to answer that question, it depends on the what happens really in the
Mm-hmm.
future. So
Yes.
if there's a breakdown in the relationship, breakdown in marriage, there has to be a property settlement. And then the court will determine, based on the circumstances, whether or not the other individual, will have a share, even though their name is not on the title deeds, whether or not they will have a share in the property. Now, let's say everything is fine, the marriage goes on, and the legal owner dies. That brings it under the Succession Act now. And under the laws of succession, the wife or the spouse
Mm.
will be able to inherit.
Unless there's a prenup.
Yeah, unless it's a prenup. Even if, and there's another issue with estates, even if you decide to give your property to somebody else instead of your wife in your
Mm-hmm.
will, your wife can still claim
Mm-hmm.
an interest in
Wow.
that property.
You're gonna have to pick that up with us next week
Yeah, yeah,
because
that's a separate issue
that's a hot
altogether.
one. That's
Yeah,
a
yeah.
hot one. Because can you imagine that? So
Yeah, yeah. So it all depends. To answer the question, it all depends on what happens to the
what
relationship.
happens? Wow. Well, oh, listen, this one was fast. This one, attorney was fast. And so I sent you a question from somebody. Okay, so the person who sent me the question at 8:29 on WhatsApp, all I can do is to tell you sent, meaning that I did send it up.
Yeah.
I'm taking this session very seriously. I sent it up, and when I get the response, I will send it back to them. Okay. Sorry, I could not answer. We could not get to answer all the questions, and you didn't get to make all of your presentations.
Right. No, no, I didn't. But this what happens. You branch off into other areas. That's not a problem.
Yes, yes, yes. Is what what they want the questions they're asking. Well, I will allow you. Just take half a minute and say just one last thing that because I could tell you want to say something. Go ahead.
Right. Yeah. So just again, this will be something you will keep hearing from me. Make sure you are aware of what you own, and make sure you are aware of how much of a share. Let's say you are in joint tenants. Be aware of how much interest
Mm-hmm.
or you own in real estate or any kind of property. If you own property jointly, be aware of the interest that you have in that property. And when it comes to probate matters, when it comes to giving your interest or giving your assets to any individual, be very specific. Be specific. Let the entire world know. Whoever is reading that will, let them know you had a 60% interest, a 40% interest, and you are giving that interest to this individual. Or you're giving that interest to two individuals or three individuals, but be very specific
Very
in relation
yes,
to your estate planning.
yes, yes, yes. Wow. Well, thank you so very much.